Good mornings, guys. Long time not on video. Yeah, the load shedding is causing quite extensive problems for everybody, and especially our guys that lives mostly on the internet and electronic media. But yes, here I am this morning, this Friday morning, and I'm bringing good news, very good news, in fact. I want to alert you to the following two things. Firstly, we have our first definitive Labour Court set-down dates relating to the whole issue of COVID. These matters relate to discrimination in terms of COVID, cases that can only be conciliated at CCMA, and then the jurisdiction falls within the ambit of the Labour Court, goes over to Labour Court. It's not being arbitrated at CCMA. And the first one that we now have on roll, and I can quote you the case number is JS 451 of 21. It's a very old case, comes already from last year, and eventually we have the case being set down now at Labour Court, South Africa, held at Johannesburg, down in Ramfontein. The parties being Filani, the person's name is Motabeng, Motabeng, sorry, my mistake, Filani, and then Aspen. Now, isn't that poetic justice? Aspen being the company in South Africa who received a tender to manufacture Johnson & Johnson, and then of course we know that entry is standing empty, mothballed, because no tenders has been given or received yet for their vaccination. Okay, so that's the first goodish news. If the Labour Court says yes, we will hear your case. It means that somebody at Labour Court, one of the judges, saw something in that case to make it worthwhile for them to allocate time to that case. Labour Court is so overflowed with cases that it's very difficult to indeed get a set down for a case. And this indicates very positively on what is going on. But then, here's the big one. You will remember some time ago, the media reported extensively on a win by the medicals company Barak Medical. And they made out as if this is now the begin all and end all of all the cases relating to COVID in South Africa, and it must be seen as a precedent. I was mocked because the aid group was under the impression it's my case. My case is with Barak. It was not. It was Lady down in the Cape who defended herself, and admittedly she did not take heed of information she received from me, advice she received from me, and in the end she lost the case. However, we are waiting now the last one, Mrs. B, the famous Mrs. B case that has also been discussed tremendously on social media. But we have our first award, and it's an award that punches, and I'm going to indicate to you. Your case number is GA, Gauteng, JB, Johannesburg, 20811 of 21. It's also a case already dating from last year. Date of the award, 22 June. So it was sent already about a week ago. The parties being Chatsu and Barak Medical. Extensive, very, very well written award in which the commissioner, amongst others, says that before he came to his conclusion, he read the following awards. Now, these are similar awards. Remember, in CCMA, we're not dealing with stare decisis. In other words, we're not dealing with a precedent case like you would deal in a court of law, but commissioners are bound to a certain extent by the findings of their fellow commissioners. If they diverge from those, they must give good reason why. They must cite law or fact or reason why. But yes, they are guided by what other commissioner says on the same topic, on the same set of facts. And he says the following. He says, before writing this award, I've read the awards of my fellow commissioners under case numbers. And then he quotes a lot of case numbers, most of which, except one, was Western Cape. Now, we've seen a trend in Western Cape just before I give you the extremely good news. That down in the Western Cape, you simply don't win cases on COVID. Usually the cases there are settled, and when it comes up for arbitration, It is usually found against employees on very strange and technical and legalistic grounds, but we haven't seen much success down in the Western Cape. I think it's the whole mentality of the people of the Western Cape, and I'm not generalizing now, I'm speaking of the powers that should not be. The whole mentality there is that we are still fighting this pandemic that's going to kill us all, and everybody's going to die if we don't take the meds, and there's 10 million graves already dug. So if we don't take the vaccine, 1 in 5, it's indeed correct. We have about 50 to 60 million people in South Africa according to stats. I don't know if you're aware of that age group. So 1 in 10, 1 in 5 means 20% of the population dies. They are still with that mindset, and therefore out of the Western Cape, we're not finding any success. Okay, so he says, I take note of that. This is now a red line commissioner sitting here up in Joburg, Harrison Street, a red line COVID commissioner, specifically of the specialist group of commissioners dealing with these issues. And I also made mention of this in a lot of my prior videos. There's a specialist group of commissioners at Harrison office. Remember, the usual CCMA office is at Fox Street down near Gandhi Plain, where the ordinary cases, all the other ordinary cases are at. They've converted office space at Harrison at the head office itself. It's a different building in Johannesburg for red line cases, for COVID cases, with specialist commissioners dealing with those cases. Okay, so he says, I took notice and I read the awards of my fellow commissioners in, and then he cites a host of Western Cape cases and one Johannesburg case. Then he delves into Barak's vaccination policy. He delves into those regulations that by now we know were ultra-virus, but even despite referring specifically to those regulations, he then comes to the following conclusion and finding. And I'm going to read the award. It's a very long award, so let me just page through it. He finds the following. Order. The dismissal of the applicant was substantively unfair. So in other words, they were not fighting against the procedure, they were fighting against the reason, that being COVID, the vaccination policy, the fact that the employer didn't follow that policy, or according to the employer did not follow that policy, and therefore it was misconduct or capacity. It says the dismissal of the applicant was substantively unfair. Win. But then the respondent, Barak Medical, is to compensate the applicant the equivalent of 12 months salary, amounting to 279,600 cents. 280,000 won by this employee. 12 months maximum compensation. Boom. Barak out of the water. Dead. There is no order as to cost. Usually the CCMA wouldn't award cost. The award is to be paid by 25 July. We actually passed that point, so they gave only 3 days after the award for the, sorry, it's my mistake, July. That's in a month's time from now on. Okay. We have our first definitive win. We have a case where a commissioner, a specialist commissioner at Harrison Street very clearly indicated, very clearly said, we are dissatisfied with what we are seeing. We read all the other awards. We don't agree with those awards. Here's the reasons why. And we not only let the employee win, we hit the employer with maximum full compensation, 12 months, bam. Now that is sending a very clear message out there. We'll be distributing this award throughout the day. It will also be posted in full on my Telegram channel. I'm awaiting the Reisenaar case, the other Barak case that we're still outstanding on. I suspect there we will also win with full compensation. We, being the good guys, not per se myself, it's very clear what has happened here. The CCMA is making a stand. This is now the second one. You will remember the Colin Smith case about unfair suspension. And now we have a definitive award about unfair dismissal, both related to COVID, very clearly red line cases, COVID cases, in which the CCMA came out and awarded its maximum. In Colin's case, 2 months, it was 2 months that he was sitting at home. The commissioner didn't even squamped about it. He gave him the 2 months and said it was unfair suspension. You can't let the worker sit at home because your policy is saying you must vax. Secondly, we have this one now that says, Barak Medical, your whole regulations, your whole code, everything that you did was incorrect. You couldn't dismiss the employee, substantively unfair, boom, 12 months full compensation. The CCMA has taken and is taking serious note of what is happening around us. A couple of months ago, the CCMA was very closed up. When I started to appear there with these cases, I realized that the commissioners were totally misinformed on the back of, for instance, the Health and Children of the world coming to webinars with those commissioners and telling them absolute nonsense. In the meantime, the commission has seen, the CCMA has seen the effects of this United States-based, Judge Judy-based type of law that has been forcibly put into our legal system, whereas we are sitting with the best labor legislation on earth, right? And they realize the effect of that because the CCMA is overflowing with COVID cases. It is overflowing with COVID cases. Down in the Cape, you're now waiting 90 days before you get an arbitration date, whereas usually it would take 21 days, which indicates to yourself what's going on there. KZN, exactly the same. We're sitting and waiting for dates. We're not getting dates. COVID redline cases here up in Johannesburg. When I file a case now, I file it directly to Harrison Street. They distribute it back to the other offices. So maybe other practitioners, you can also follow that. File it first on head office, Harrison Street. They will send it on to the next one. That expedites the case usually with quite a few weeks, because it doesn't end up in a mass of cases coming into the ordinary system of CCMA that first must now then be sifted to see if it's COVID, it's not COVID. Okay. But there you have it, guys. There you have it. I'm awaiting that other award, of course. And then, yeah, we haven't had a finding by the Labour Court yet. But if the Labour Court comes and they say, we want to hear this case now, it seems to me somebody at Labour Court has also taken tremendous cognizance of what is actually going on in South Africa relating to so-called COVID mandates in the workplace, which was unfair, illegal and unconstitutional from word go. Remember what I said on my videos, why I started my campaign. All my clients will know that you start off your package that you receive after my proof of payment is received by administration. You receive in your package my opinion. There's two of them. Very clearly, firstly speaking of general law, secondly speaking of the Constitution and how illegal the whole issue of vaccination, false vaccination in the workplaces actually is in South Africa. So I've been validated now over and over again. Those attorneys and advocates and consultants running out there mock still misadvising their clients. Mr. Client, if you end up with an award like this, like the one that Barak did, I want you to go to the attorney's firm or the advocate who advised you or the consultant who advised you and then say to him, it's pay time now. You advised me wrong. You gave me a copy and paste Judge Judy, United States of America, piece of legislation that didn't fit anywhere into the South African scope of legislation, and therefore I'm now losing cases. And if you fired multiple people, Old Mutual, 600, it's going to bankrupt you. Standard Bank, stop. Stop. You're seeing the light now. It's not Skulk saying this. There's no use your attorney's firm writes me a letter to say, Skulk, shut up now. If you don't shut up, we're going to even take criminal steps against you. What criminal steps? Criminal steps in terms of what law? Don't try and threaten me. It's not going to work. It's going to just make me harder and more hardline on the issue. But Standard Bank, take notice of this. Discovery. Hein, you guys, it's there. It's in front of you. And you want to go to CCMA with those cases that Tukisu presided over, where the employee didn't even appear in the disciplinary inquiry. And you believe that you're going to win those cases. What's the chance of that? A full round zero. Okay. Very good news. I hope to come online again later today. Bring you further good news. As I reported this morning or yesterday, I'm not sure. Many big companies, amongst them AECI, has simply shelved their vaccination policy in total. And others has extended it again, have extended it again, simply meaning they know they are in the wrong, they know they can't go on with what they were doing. It was always going to come to this point. It was always going to come to a point where now we're sitting with the minister saying we actually published the regulations, the codes, in terms of the wrong section of the Labour Relations Act, which makes everything that followed from there and flowed from there illegal per se. We don't even have to go and prove that any longer. It's been by admission by the minister himself. But then, even if the company falls back on the substantive issues and say, yeah, but there was a pandemic and we had to ensure safety in our workplace, it's very clear there's American law that was brought in, Judge Judy law that was brought in, clearly doesn't find any place in a South African legal setup. And therefore you're going to lose the cases one by one. And you see now, at maximum compensation, 12 months, boom. Very unusual. I was a commissioner myself for many years. I know how compensation is calculated. I defended on both sides, employers and employees in CCMA. I know exactly how commissioners come to their conclusions. If you win a case with full 12 months compensation, it means that your client, your employer client, made a terrible screw up of what he did. And the commissioner actually found malafides on their side, and that is why they are hit so hard with the compensation of it or awarded to the employee. So take note, I will publish that specific award on my channel now, my Telegram channel, on Facebook. Unfortunately, I can't publish PDFs, but I will take screenshots for you of the relevant parts, and please utilize, employees, please utilize those in the workplace. Take it to your employer, to your HR department, and say to them, guys, look what happened here. You have two cases now, the Colin Smith case and the Barak case, and we're waiting a third one, also Barak, and a couple of other ones that I'm not going to divulge now. But start using those, because we have decisions now already by CCMA. So, Mr. Employer out there, what is the chance of you winning your case if the CCMA already is on a totally different plane in seeing exactly what's going on? And that, my friends, is me signing off for now. As I said, I will speak to you later today.